People vs. Montierro, GR 254564, July 26, 2022. Facts. Erick Montieró y Ventocilla, alongside another accused, Cypher Baldadera, in a related case, was charged with illegal sale of dangerous drugs under Section 5, Article 2 of RA 9165. The seized shabu weighed 0.048 gram. Montierro entered a plea bargaining proposal, offering to plead guilty to the lesser offense under Section 12, possession of drug paraphernalia. The RTC approved the plea bargain despite the prosecution's objection, which was based on DOJ Circular No. 06117 and DOJ Circular No. 02718, both restricting plea bargaining in Section 5 offenses. Montierro was convicted only of the lesser offense, Sector 12. The Court of Appeals dismissed the prosecution's petition, ruling that DOJ Circular 61 improperly encroached on the Supreme Court's rulemaking power and treating the prosecution's objections as waived for not being properly raised before the RTC. Issue: whether the RTC erred in approving Montierro's plea bargaining proposal despite the prosecution's objection. Whether DOJ Circular No. 61 and related DOJ circulars can restrict plea bargaining beyond what the Supreme Court's plea bargaining framework allows. Ruling 1. RTC did not err. Plea bargain valid. The Supreme Court affirmed the RTC approval of the plea bargain. Key reasons: plea bargaining is allowed in drug cases pursuant to Estepona v. Lobrigo, AM number 180316 SC. Plea bargaining framework expressly allows accused charged under Section 5 to plead guilty to Section 12 when the drug quantity is between 0.01 to 0.99 gram, as in Montierro's case, 0.048 gram. The prosecution's objection alone is not controlling. Plea bargaining is primarily within the court's discretion based on the framework. 2. DOJ Circular No. 61 cannot override Supreme Court rules. The court ruled that DOJ circulars cannot restrict or modify the Supreme Court's plea bargaining framework, as rulemaking and procedural authority belongs solely to the Supreme Court under the Constitution. Thus, the DOJ's prohibition against Section 5 plea bargains cannot invalidate the RTC's acceptance of Montierro's Section 12 plea. Doctrine: Supreme Court's exclusive rulemaking power. DOJ issuances cannot amend, alter, or restrict plea bargains allowed under the court's procedural framework. Plea bargaining in drug cases, governed by Estepona v. Lobrigo and AM number 180316 SC. The accused may plead guilty to Section 12 when charged under Section 5, if the drug quantity falls within 0.01 to 0.99 gram. Prosecution's consent is relevant but not absolute when the Supreme Court's framework expressly authorizes the plea. Disposition: set aside. The respective cases of Cypher Baldadera y Pelagio and Erick Montieró y Ventocilla are remanded to the court of origin to determine 1. Whether the evidence of guilt is strong, and 2. Whether Baldadera and Montierro are recidivists, habitual offenders, known in the community as drug addicts and troublemakers, have undergone rehabilitation but had a relapse, or have been charged many times. Furthermore, Baldadera and Montierro are ordered to submit to a drug dependency test pursuant to AM number 18-03-16 SC.
Got some ghosts I keep around. They ain't quiet, they just talk loud. Built this house on dusty ground. It's a heavy kind.